NACDL is the association of the nation's criminal defense bar.
Welcome, everyone. My name is Monica Reed. I have the pleasure of serving as the Director of Advocacy here at the National Association of Criminal Defense Lawyers. And we wanted to start off by thanking you for joining us for this afternoon's webinar, which will be Race in the Criminal Legal System, Racially Charged Misdemeanors. So today's webinar discussion is going to be focused on the Brave New Film's recently released documentary entitled Racially Charged, America's Misdemeanor Problem, of which NACDL, through Ronnie Hoffman, which you'll hear from later, provided subject matter assistance. So the primary inspiration for this documentary comes from Professor Alexandra Nadapov's book, Punishment Without Crime: How Our Massive Misdemeanor System Traps the Innocent and Makes America More Unequal. And we are excited to have her joining us for today's discussion. This short film traces America's modern misdemeanor system back to the post-Civil War period, really unpacking the criminalization of certain conduct as a means of social and economic control over Black Americans. And hopefully, as you heard or watched in the film, and as Professor Nadapov states in the film, many misdemeanor offenses can be understood as mechanisms of social control, not designed to catch dangerous individuals, but tools for police to exercise their authority. So today's discussion is going to be moderated by Lisa Wang. She is a past president of NACDL, and she is the current president of the NACDL Foundation for Criminal Justice. And she will be joined by two excellent panelists, and I will let her further introduce them. So today's discussion and conversation is a part of NACDL's Race in the Criminal Legal System discussion series. And so over the course of the year, but really longer, it has sought to highlight how race intersects with the various issues in the criminal legal system, navigating these racial disparities in ways to advocate for change. So a question, and we've been asked this by those who've attended some of our past series, is why are we discussing race in the criminal legal system and pulling out these racial disparities? At one point, I'm sure you've heard the phrasing that the system is broken. But I would say right now, we've actually been hearing more often that actually the system is working exactly as it was designed to. So the disproportionate impact of our legal system on Black people and other communities of color didn't just happen by happenstance. It was very intentional. And as another professor in the film states, Professor Teresa Johnson, she mentions in the film that the justice system was, after emancipation, was weaponized against Black people. Another participant in the film also emphasized how these laws didn't happen by chance. They are part of a system to continue to oppress Black bodies. So because these policies and these choices were intentional, we have to be intentional in our advocacy. So that's what brings us here today and why we're having discussion around race and misdemeanors. So we're not screening the film today. We will show a small trailer for the film. So I hope you were able to watch it before this conversation. But if you weren't, I think you can still benefit from hearing from our panelists, and hopefully you'll get a chance to watch the full film at another time.
You act like I really just committed a serious crime.
You did do something illegal. You crossed the crosswalk.
Misdemeanors have historically been the chump change crimes that we didn't pay attention to.
I've done nothing. All I'm trying to do is go home, man.
These laws didn't happen by chance. From the Reconstruction era to modern day, you see the fingerprints everywhere.
John Clark was convicted on a misdemeanor gambling charge and was forced to work on a chain gang.
To sell prisoners into slavery, you first have to arrest lots of people.
You say you're going to jail, and I'm like, what for?
This will be a part of my story for the rest of my life.
The emaciated convict laborers work their entire days barefoot.
You're their slave with their shackle on your foot.
The problem isn't bad apple cops. The problem is the system is working the way it's supposed to.
So it's the clip is a great way to start off the discussion. I know that anybody watching that, it's hard to watch. There are a lot of emotions that go along with watching the film. There are a lot of emotions that go along with reading the book when you read the professor's book. But the bottom line and the message here for all of you, and I see a lot of defender friends out here, we hear you. We know your frustration. The misdemeanor challenge is something that really needs to be addressed head on, mainly by defenders, those folks in the trenches that really handle the brunt of this very difficult work. And we're now going to talk about this enormous net that's cast by misdemeanors and how it has maybe not gotten the focus it should have, and being able to answer those questions like Monica posed to us about why are we talking about this? Why are we talking about the intersection of race that has to do with and being able to actually answer these questions head on, because the history of this country, the history of race in this country, and the intersection with the criminal legal system is undeniable. So hopefully we're going to give you the answers to some of this. It'll start a discussion that hopefully will be honest, not only here today, but within your offices. I know when I was a defender, some of these hard discussions were not really being had. And I think that that is changing. And I hope that this will serve as really that impetus to let's start talking about this and let's start really changing it up. So I want to immediately get to our incredible panel. I'm so excited because I have two of the best experts in the country that are going to be able to talk to you. And I'm going to let them introduce themselves. We talked about this earlier. And I always feel like when you're reading, it's like when you're in court reading your opening statement, okay? It doesn't feel genuine if I'm reading the introduction. So I'm going to let each of the professor and Bernice introduce himself. And I'll start off with you, Professor Natop. If you would please introduce yourself, tell us a little bit about you.
Hi, everyone. Thank you so much for having me. It's great to be here, part of this wonderful panel. My name is Alexandra Natapop. I'm a professor at Harvard Law School. I teach criminal law and criminal procedure and evidence. I'm the author, as Monica said, of the book Punishment Without Crime, which is about the misdemeanors, the American misdemeanor system. It was the inspiration for the film, which I also had the opportunity to work on. I think it's just a poignant and helpful and on point film that teaches and hopefully will inspire. Before entering the legal academy, I was an assistant federal public defender in Baltimore. And prior to that, I was an Open Society Institute fellow, working with neighborhood organizations and doing educational work in West Baltimore, which is where I learned everything I know about misdemeanors and the criminal system. And thanks so much for having me.
Thank you, Professor. And Bernice Corley, if you could go ahead and introduce yourself.
Thank you. It's a pleasure to be here. It's certainly an honor to be on a panel with Professor Natapop. My name is Bernice Corley. I'm the Executive Director of the Indiana Public Defender Council. It's a state agency here in Indiana, and our purpose is to support public defenders and public defense as a whole. So on the one side of our house, we provide literally research assistance and support to public defenders in their work. And then on the other side, we champion and work for criminal justice reform and improvement of our criminal justice system. So we do a lot of policy work and engagement with other criminal justice stakeholders. Before serving in this role, some highlights from my career: I was a public defender in Marion County, which is Indianapolis, Indiana. I served at the trial level, and then for a number of years, I worked as a contract appellate attorney for them. So pleasure to be here.
So I think that should all make all of you feel really good about this conversation, because we were all defenders. I was also a state public defender for 13 years. So we're coming to you knowing how it feels, having been there with you. Bernice is still there, in the trenches. So I think this is going to be an incredible conversation. And important to all of us is the Q&A. So I'm going to watch the Q&A as we moderate here, but this is going to be a pretty organic discussion, and we really want you all to be engaged, ask us questions. We're here all together on this, so now is your moment. So I'm going to start with you, Professor Natapov, because I've had the opportunity to read the book. I encourage everybody. I actually downloaded it as an Audible, listening to it on my walks. And, I would stop and say, I need to write something down here. I need to write down some of these statistics. I need to write down some of these things that she's talking about. So if you could, Professor, what was the impetus for this? And, where did this come from? Why did it inspire you to write this book?
All the sources are in the notes, Lisa. There are about over 1,000 notes at the end of the book. My hope is that not just the analysis and the stories, but the information and the data will also be helpful to lawyers, to litigators, in thinking about how to handle misdemeanors in our system. So let me start with the frame that I always think is so underappreciated. 80% of American criminal dockets are misdemeanors. This is what our system does most of the time to most people. It's how most people will encounter the criminal system. For many of us, I think it's true. It's certainly true for me. I trained in misdemeanors. I was lucky to be in a highly resourced office that took misdemeanors very seriously, but I also was aware that they were they were often compared to what were considered the real or the serious felony offenses. And my hope is to destabilize that hierarchy a little bit. The thing that we do to 80% of the people in the criminal system has got to be the important thing. To take nothing away from 3 strikes, to take nothing away from those long mandatory minimums. This is mostly what our criminal system does. So the book is an analysis of how big the enormous footprint of the system, both legally, but also socially and economically, and of course, racially. As I mentioned before, I learned about misdemeanors in Baltimore. My public defender friends are constantly laughing at me when I write about a number of aspects of the criminal system. And they say, well, we knew that. You learned that here. I said, well, you should have written a book about it then. So I was trained in Baltimore by my neighbors, by my clients, by my students in the importance of misdemeanors. This is their everyday lives. They expected to encounter the misdemeanor system. They expected to be stopped and arrested and convicted and jailed for chump change. And so that was really the first impetus that I had to appreciate, which I hadn't before, just how important this system is legally, but also humanly.
So Bernice, when you hear about 80% of the docket, the criminal docket is the misdemeanor court, are you surprised by that? Are the numbers syncing with your public defender offices around the state and the country?
Oh, I think our colleagues here in Indiana probably sounded like your colleagues in Baltimore. We should have written a book. So every year, our prosecutor counterpart does a summary of the highest charge offenses in Indiana, divided by misdemeanors and by felonies. Overwhelmingly, our greatest number of charges are misdemeanors, as the professor said. That absolutely bears out here in Indiana. But also what bears out, as she shared, is systemically, we pay very little attention to misdemeanors. So with respect to resources, with respect to accountability, transparency, data tracking, none of it's there. So when I say none of it's there, it's very difficult to tell a whole story about how people are impacted with data in Indiana.
If I could just follow up on Bernice's point, because it's such an important one. When I decided to write the book, one of the things I realized was that there was so little data on the public record, and it's tough to write a book about a phenomenon that is, so invisible in that way. And I sent records requests to every state AOC, every state administrative office of the court, asking for their misdemeanor data of precisely the kind that you're highlighting is so hard to get, not just for scholars and researchers, for public defenders, for prosecutor offices, for courts, all the stakeholders in the system. And we're really, we are working in a certain amount of ignorance. I couldn't write a whole book about the process of trying to get information. I got some, it's partial. there is more information, I think, and more data collection today, but it's still, as you point out, just such a pressing problem that so much of the system is essentially underwater. We're not even keeping track of it in a way that permits sort of rigorous analysis.
So it's interesting because you talk about, this data, and obviously in the state system, and it depends on the state, misdemeanor court is overwhelming. You have defenders who are sometimes handling up to 1,000 misdemeanor cases at a time. And I've seen that in many, many states. But that's the training ground for defenders. So when I was a public defender, we were trained, and we were very strict in the Colorado State Public Defender System. We had probationary periods. I don't know if it's still like that, but we couldn't wait to get to felony court. I mean, you really weren't anything in the office. You didn't have the respect until you were a felony lawyer, right? And so it was kind of the training ground, and that's where we started. And then in our system, we went up to juvie court, and then you worked your way up to felony court. So Professor Natapov has kind of messaged here to, I think, a lot of us is we got to change that up. We got to really put more emphasis on the front end of our folks getting in the system, which is misdemeanor court, and really having lawyers pay attention to that. But how do we do that, Professor Natapov? How do you deal with Mississippi, Louisiana, Indiana, Missouri, places that don't have the money for defender systems?
So, as you both pointed out, the defender system never has enough money for anything. So it's not as if we're fully funding our felony practices either. Again, I should note that I was very fortunate to be in a federal office where there were resources. I did not have the kind of crushing caseloads that my city, Baltimore City and state counterparts had. But the federal system is a tiny sliver of our criminal practice and our criminal system. I think, so I just want to flag, as Lisa pointed out, part of the challenge of the misdemeanor dockets is the lack of misdemeanor representation. That we have jurisdictions where half the people are not getting lawyers, not because of Scott versus Illinois, not because they're not entitled to them, which is a whole separate problem that, that we can talk about, but they're constitutionally entitled, and the courts are just not bothering, not appointing lawyers in clear violation of Argersinger and Gideon. And a decade ago, the NACDL issued a very important report, Minor Crimes, Massive Waste, the problems of the American misdemeanor system. And it was the first to take a systemic look. This was back when there was even less data than there is today. And that report focused on the lack of representation. And it was an effort to evaluate how big the system was, and then just how much the right to counsel was being violated. And of course, it would surprise no one that what that report found was widespread violations of the right to counsel. That issue, I think, has risen since then, since that important report has risen to the fore. There's been a Senate hearing chaired by Republicans about the violation of Gideon and the right to counsel in misdemeanor courts and misdemeanor dockets. We've now seen studies in numerous jurisdictions. Courts are being sued. South Carolina, but a number of cities just settled a bunch of cases because they weren't providing counsel, and now they're, entered into consent decrees. So we are starting to push back, I think, to demand more money from legislatures, to demand more money from the system to fund what is obviously a long-established constitutional right.
Bernice, I mean, criminal legal reform is all the new rage, right? Everybody's interested in now helping a system that we all have been part of and been, trying to do things in for many, many years. And I'm wondering, within your offices and the public defender system, what if you revamped and said, misdemeanor court's the most important thing you're going to do? Do you think there'd be resistance within? Do you think that's something that's a possibility that we can do across the country?
So I'll focus, if you don't mind, first on Indiana and your initial question of, can we fix, what can we do to fix this? Like the under-resourcing of public defense, et cetera. And from where I sit, and I feel like this is probably true in every state, the money is there. It's the priorities and the will. And so from where I sit, I see money everywhere. I see money in keeping people in overcrowded jails and the staffing it takes to do that, and money in court staffs, et cetera. Like, I see resources everywhere. It's been a real challenge to educate just on basic civics of why people should give a damn about public defense and why public defense is critical and how it is really like the bedrock of a free society. So for me, I almost feel like we all, where we sit and where we touch people when they ask you the question, like, how could you do public defense? That's, how can you do it? That's so terrible. I think if we could pause and use all those moments, although I'm sure we're all tired of doing it, but just continuing educating people, continuing explaining why they should care and why it is important. And then where we have space, resource people with the purse strings, continuing to educate of why it makes more sense, even economically, to put more resources on the front end, on public defense, on these smaller things, even in terms of police resourcing, how we use our resources. If we shift our priorities, that we can have a safer, more prosperous system if we would stop abusing the poor and minorities. So that's kind of how I frame how I approach things.
If I could just double down on the way Bernice put it, the problem is that we don't give a damn. It's really the heart of the misdemeanor problems. We dismiss, no pun intended, misdemeanors as petty, minor. We literally give them names that proclaim that they're unimportant. And yet, as I think we've all been, educated about more recently, but many, of course, of the folks who are listening have known this for a long time, the consequences of sustaining a brush with the misdemeanor system, and I say a brush with the misdemeanor system advisedly, not even a conviction, because being stopped for a misdemeanor, being jailed, arrested and jailed, being detained, being on diversion, having to go to court, all the costs of being in the system, as Malcolm Feely so famously said 30 years ago, the process is the punishment. And then the collateral consequences of a misdemeanor arrest, that record that interferes with employment, of course, the conviction itself, which is getting people kicked out of public housing. They're losing public benefits. They're losing their immigration status. They're losing their student loans. They're losing child custody. They're getting evicted. I could go on and on and on. These are the true punishments of the misdemeanor system. And we can call them petty all day long, but there is nothing minor about what is actually happening to people going through this experience. And so I just think it's so well put that the education is to care. The education is to realize that George Floyd was stopped for a misdemeanor, that Eric Garner was stopped for a misdemeanor, that Philando Castile was stopped for a misdemeanor traffic violation. This is the net that sweeps people in, that is threatening Black men's lives for chump change for these low-level offenses. And when we appreciate that, when we give a damn about how the misdemeanor net is threatening people's lives, their livelihoods, their families, their communities, then we can have the right conversation about resources.
So it's that making that connection of what you're talking about, but both of you are talking about, and making folks care about it, that it is important, that it is significant, and frankly, getting our defenders excited to litigate and to do something about this. I mean, to me, that matters. And, Bernice, when people ask you, how do you do this? I'm always like, how couldn't you do this? I mean, what the hell, what does that even mean? How could you not do this if you care about, human beings? So making that connection. And so one of the things, Professor Natapov, in the book and in the movie is that connection with history, the evolution of the Jim Crow laws into what now is petty policing and other things that you point out in your book, but is making that history really live and connect with us as defenders. And so I'd like you to talk a little bit about that, because, you know, we're seeing a lot of that. I mean, we see Jeff Robinson and the film coming out and making all the connections there for us and making that really live for us. But I think in your book, you're really able to kind of hit it home, make it land. And then to me, the next step would be litigating it, pushing it in the courtroom and making it land with the judges and the DAs as well. I don't know. So talk to us about that history connection.
So I think history is so important for the defense bar. I'm so proud that I was a public defender. I'm so proud that I was a defense attorney. And part of that is the history of what that role has meant for our constitutional democracy, that we don't really have a Bill of Rights. And even, I say even the Supreme Court has recognized, you know, that the Bill of Rights is not meaningful unless we have the right to counsel, to gird it. And so I think that understanding of our historic role, as well as our everyday litigation lawyer role, is an important part of the story for us as attorneys. And then, of course, it's a crucial part of the story for understanding our criminal system and our misdemeanor system more specifically. I think one of the things that's happened, you know, over the past decade or so is that we've been in this conversation about mass incarceration. We've really educated ourselves and had a much deeper, more thoughtful conversation about the history of mass incarceration, the role that mass incarceration has played as a form, not just of criminal law, but of race discrimination. It's one of the reasons we have racial inequality in this country is because of mass incarceration. And so I think historically it helps to broaden that lens and understand that in many ways it started with misdemeanors. After the Civil War, when the Southern states were pushing back against emancipation, their pushback was enabled by that loophole in the 13th Amendment that permits involuntary servitude as a condition of punishment. And so what they did, and the clip that we just saw features Douglas Blackman. He was one of the people who was speaking, and he wrote the book Slavery by Another Name, which is this historical story of how Southern states expanded and converted their misdemeanor apparatus into a way essentially of rounding up Black people, often based on vagrancy or disorderly conduct or walking along the railroad track, these minor chump change offenses, specifically so they could be convicted, fined in ways they could not pay. This is sort of the predecessor, the roots of our modern debtors prison system, intentionally fined in ways they couldn't pay, so that in order to work off their sentence, they were sold. They were sold to factories, they were sold to plantations, they were sold to mines as punishment. And this whole apparatus grew and created many of the institutions that we still see lingering today. And when Monica said at the beginning of this conversation that it helps to understand misdemeanors as a form of social control, I would add it helps to understand them as a form of economic control, that they are a mechanism by which we have historically stripped people of their labor, converted them into essentially free labor, again, since the end of the Civil War.
Bernice, you know, I'm going to ask you a more difficult question that I have seen happening a lot in defender offices and defender organizations, and that is we have a lot of white allies. We have a lot of white allies in a lot of things going on in this country. The Black Lives Matter movement. We have mostly white lawyers in the defender trenches. That's the majority of folks. And sometimes, and I've heard the discussions, you know, it's just too much about Jim Crow and the history. And, you know, we've heard so much, and that's not going to, you know, my DA doesn't care, my judge doesn't care. And frankly, I'm not sure how much it resonates with me either. How do we connect and make sure they care as much as we care, because these are our people? How do we do that?
You are not kidding. That was a hard question. You're right. So it's I see it as a chicken and egg problem. And what I'm going to describe, I've studied defender systems in other states, so I know Indiana is not an outlier in this instance. So again, chicken or egg, I don't know, but part of our defense system in Indiana is we lack judicial independence. We have some offices where there is a chief, there's an actual office, and they're completely independent from the court. Our office in Marion County is an example of that. In other counties, smaller counties, we literally have judges who appoint the defender. So, add that as a background noise to have a situation where you have defenders who come into court knowing my boss is the judge, I want to keep this job. You're already working with perhaps a mindset where they're only willing to push so far. So you add that element in with also perhaps being, just not personally bothered by, or not bothered, that's not a right way of saying it, but not really hit by the issues of the day. It becomes easy to not push, to not press, to not concern oneself with, even if I care, there's nothing I can do about it. Even if I care, there's nothing I can do about it. And so sometimes there's hostility when you bring up these issues with people who are in a mind frame of, even if I care, there's nothing I can do about it. I've had conversations where I've brought these issues up and there's an immediate, well, we don't have those problems in this county, we don't really have any minorities. It's like, no, that's not true. Here's the census information. I know you have migrants here who pick, whatever produce in whatever season. You do have people of color, and these are issues in your community, but there's sometimes or often a wall. And I don't know if that wall is because they feel like there's nothing they can do about it, or if it's that they're not connected to the issues of the day. I don't know what the source of it is, but it's challenging. So I think I didn't answer your question, but it's challenging.
Yeah, I don't know if there's an answer.
Can I chime in?
Yeah, absolutely, Professor.
So I'm white, in case you can't tell on Zoom. And I have to say, I'd just like to add to Bernice's description of the challenges twofold. One is there's nothing, the idea that there's nothing we can do about it, I think is a false choice. So what we can always do is represent our clients with respect and understanding. And that requires some reaching across experiences, even understanding history in a way that I think is central to the representation function. One of the things I learned from my clients who in Baltimore were almost universally African-American was that what the representation meant to them wasn't always the same as what I thought the representation was about, that I had to hear their perspective, their understanding of what it meant to them to be represented with dignity, with respect, with understanding, how they wanted their lawyer, for example, to interact with their families or their children, or understanding the circumstances they had come from. And all those things were racial. I had to educate myself to be a good lawyer for them. And I saw that as part of my job, but I also saw it as a benefit to me to understand what it means to be a good lawyer better, what it means to be an American, to live in our multiracial society with this history. And so I don't think it's necessarily about, can I file a motion? Although I'm all for filing motions. But before we even get to the motion, I think it behooves us as attorneys, as people who have committed to represent vulnerable others, particularly as publicly appointed counsel, but not only, that understanding race is part of that job. And I think that the film does a wonderful job at making accessible and clear what those linkages are. So I think I encourage my students to understand these issues as part of being a lawyer. And I do think this past year, the year of George Floyd, the year of Black Lives Matter coming to the fore in a way in public consciousness, that has to be part of our conversation as defense attorneys. It has to be part of how we understand our role, for what it's worth.
It makes me think back when I was a young lawyer, this discussion, when I was a young lawyer, I had a client, I'll never forget him, an older African-American gentleman on a misdemeanor case. And I remember him saying to me, I don't really need you to understand me. I just need you to fight for me. And that was very interesting to me because in many ways, particularly in misdemeanor court, and even with client-centered representation, which is an incredibly wonderful thing. I know Jennifer Saletti, I see Lindy Frolitt, some of my defender friends on this. The client-centered representation is so important, and it wasn't what we called it when I started, but that fighting for them made all the difference in the world. And so the litigation part that you talk about, Professor Natapov, is so important, and we'll get to that. But I want to answer some of the questions here. So I've written that down in litigation, don't you worry. We'll talk about that because I know you really want to talk about that. But here's some of the questions so that everybody knows that we're seeing them. So Lindsay Smith asked, and I don't know if Lindsay can pop up, I don't know how this is done, but I've heard law enforcement argue that arresting people for misdemeanors involving public intoxication and or violence prevents later felony offenses. Is there any basis for this argument?
So that, Lindsay, that theory is called broken windows theory. It's a theory, it's about 20 years old. And it was one of the reasons, in fact, behind the explosion of stop and frisk in New York City, which, as some of you may know, has been the subject of constitutional litigation because it was so racially skewed. The way that they did it, and the court found intentional race discrimination in the way that broken windows was being implemented. That model spread to a number of cities, LA, Chicago, many cities adopted. And although I'm not a criminologist, the trend appears to have retracted, that many cities have let go of that model. And I think it's for a number of reasons. One goes to your question of, does it even work? And I think the bottom line is there has never been any proof that it works. There have been stories, cities or police departments claiming that essentially the over enforcement of misdemeanors explains some drop in crime or explains something else. That those claims have not stood up to rigorous empirical testing. What has been shown is how costly it is. Socially, racially, in terms of communities being over policed, in terms of the destruction of trust and faith that the community has in police, who are constantly stopping them and frisking them for nothing. And so I think that the tide has turned away from that model, but you're right to identify this idea that has been around for some time, the idea that the model is, if you fix the broken window, you're sending a message that will deter more serious crime. And that proposition has never been empirically established.
And in your book, I know that you talk about, in giving statistics, in 2015, 11 million folks were arrested. And that meaning 1 in 3 Americans will be arrested for a non-traffic offense before the age of 23. And for men and people of color, that's obviously even higher, which we know, we hear it, but to actually see it written out and statistically, I thought it was so stark and it's just so scary, right? And I always think of things in demonstrative evidence, right? If we can see it, we believe it. And those numbers are so important to know that that's what's out there and that's what's really happening. It's not fake news, it's real, right? Bernice, let me ask you the next question that I see here from Katie Stanford. Katie says that she sees a lot of mentally ill clients who are charged with tons of misdemeanors directly stemming from mental health issues. And then in addition to being civilly committed, often the criminal justice system is not the vehicle for helping our mentally ill clients. And what are your thoughts on this? I have so many of these clients and it's all stemming from mental health issues, and the state just keeps charging them.
I see the same thing in Indiana, and the way I feel like many states are organizing their resources around substance use, misuse issues, mental health issues, is they're almost treating the criminal justice system as the gateway for help. So if you need mental health treatment, there's no way, very few ways in Indiana to get it unless you have, insurance, means, et cetera, support system. If you're poor and you do something, then you're charged, and that's how you get mental health treatment in Indiana. Same with substance misuse issues. It's if you need assistance, there's no way to do it unless you have private insurance, unless you're charged with a crime. And then all these doors and opportunities for help open up. And so somehow, as advocates, as concerned people, we have to work to decouple the criminal justice system from the systems that actually need to be available to help the majority of people that we serve who have underlying or co-occurring condition, their mental health illness.
Bernice,
do you think that, I'm sorry, can I just add to that? I think that there's a lot of alliances that can be built around those insights. I'll just mention, so Sheriff Ed Gonzalez, he just joined the Biden administration, but he was the sheriff of the Houston jail, which I think is the third largest jail in the country. And he has been very, very vocal about how how the jail has been converted into the largest mental health institution in the state of Texas. And he said, and his point was, we're not equipped to do that. We're not doctors, we're not psychiatrists. And he was pushing back against using the criminal system as essentially the repository for this kind of failure of the mental health system.
If I could follow up, in Indiana, we're seeing that too. The sheriffs have been a great partner with public defense in pushing back on both issues, mental health and substance misuse issues. But the solutions that we're seeing, or the approaches, have been, well, we'll have a mental health wing, or we'll have addiction services in the jail. So it's still, even having those alliances, it's really challenging to get legislators and other decision makers to actually just decouple. And I mean, we have a really great head of Department of Mental Health and Association who is trying to create an off-ramp so that people aren't going in. But for Indiana, I'll say we're far from it because people are still seeing that criminal charge as the threshold for help.
Yeah.
And I think we all recognize how mental health issues are so connected to the criminal legal system. And so many of our clients, particularly misdemeanors, I mean, that's so much of what we do and have to learn about. And I will say, in San Francisco, where I actually live full time now, that Chesa Bodine has done a good job with the defense community, because they're very active in that community, where there's an emergency response team with social workers that are trained to respond to what normally would have been misdemeanor responses by the police. And they are trained to know how not to escalate, to de-escalate things. And it is really actually working. I've been watching it and, kind of following some of them, because I'm very interested to see, is this real? But you got to have the money and the tax base to be able to do those things.
Although in response to these police killings, we are starting to see cities divert what would otherwise be police resources into these unarmed mental health task forces. Essentially, we saw in the city where Dante Wright, the young man Dante Wright, was killed, just north of Minneapolis, the city council there, in response, created an unarmed team of emergency mental health responders, so that those events don't even become criminal. They start out as a civil public service. And I think, as Bernie says, you said, I think there are a lot of partnerships available and a lot of allies to be made in having this kind of conversation as we're all becoming more educated about not only the costs of criminalizing mental health issues and substance use disorders and poverty, especially during and after the pandemic, but the possible solutions that are sitting right there for us to try, and that cities are starting to try.
Right. And Katie, I don't know if that's, it's a hard one. We don't have the total answer, but, I will say that obviously if you're mentally ill, you're poor, and you're a person of color, you really have a lot of problems, right? I mean, the confrontation by the police is going to happen constantly. We see it, and people are afraid of you. People are afraid of mentally ill people, and they're particularly afraid of mentally ill people of color. That represents danger to them. They are fearful, and the way they react to it may be very different than, the older white lady who may have the same issues, right? So there really is no clear-cut answer, and it's a hard one, but hopefully as a community we'll come together on it. We have an anonymous attendee, because I love answering anonymous attendees questions, because I don't know what that means and you make us nervous. But anyway, not all misdemeanors are trivial or benign. Some are serious crimes. Do you have statistics on the type of misdemeanors that go into that 80% statistic, and how many of the misdemeanors are serious crimes? I'll let the professor answer the statistical part as well, but I agree with the anonymous attendee, particularly sex offenses. Misdemeanor sex offenses still carry registration, still carry collateral consequences of having to do psychosexual evaluation, being registered as a sex offender, all of those things, even as a misdemeanor. So you're absolutely right. There are many misdemeanors that are considered serious crimes. Professor, I don't know the stats on that. Do you?
So when I submitted the record request in the process of writing this book, I asked every state to give me that data. I asked them for a breakdown. Tell me how many DUIs, how many domestic violence, how many loitering, and for me, that the large categories that I think that it's 80% of our criminal system. Of course, it's going to be diverse. How could it be otherwise? It's not one thing. I think there's a spectrum from serious to petty in terms of the underlying conduct, but then, Lisa, as you pointed out, in the systemic response to the conduct. And so the idea is not to boil it all down to one category, but to appreciate the differences. As you can imagine, since there's very little data, as Bernie's pointed out, I did not get comprehensive. I didn't get enough national data to be able to make to come to any conclusions about the composition of the national caseload. What I could see is that every jurisdiction is very, very different. Some really double down on order maintenance offenses. Disorderly conduct is a huge 30% in some jurisdictions. A lot of jurisdictions, and I'm hoping this is changing at the moment. There's a lot of interesting litigation. I know we're going to get to litigation around driving on a suspended license. Mm-hmm. That's a huge category, but for the most part, it's a crime of poverty if people are driving on suspended because they can't afford their tickets. So order maintenance, driving on suspended, of course, low-level drug offenses have been at the front and center. I think of those as kind of the fertile areas that we can identify as arenas that we shouldn't be criminalizing, right? We shouldn't be using loitering and trespassing and disorderly conduct as a way to round people up. At the other end of the spectrum, domestic violence and DUI in particular tended to be the categories that states did break out. And they also tended to accord more resources to adjudicating those cases. There were specialized courts. There tended to be actual trials occasionally, especially in DUI, because that defense bar also has, wealthier defendants who are fueling that representation. And so the bottom line is it's a wide range of misdemeanors. It varies by state, it can vary by city. But I think you're absolutely right that we need to be thoughtful about the differences within this 80%, of course, both in terms of what conduct should even be treated as criminal, but then also the kinds of adjudicative mechanisms that we are spending resources to make sure that people are getting due process. And that varies wildly between DUI and loitering.
If I could follow up on that, and this is to get to the question in a different way. Indiana, just in our last legislative session, to the point about driving while suspended or driving on a suspended license, we have this in Indiana. I mean, it was our #1 charge misdemeanor for umpteen years in a row. Excuse me. And then many stakeholders started collecting data about it, how it became just a spiral that people could not get out of. And so fines piling up on top of fines, and essentially also understanding it was keeping people from working, or basically them having to work and violate the law all the time, to the point that through data, through understanding the impact on Hoosiers, there was a mass coming together of prosecutors, public defense, everybody to say, this is crazy. We've got to stop this. And so there was a very positive reform in terms of stopping the cycle and helping people. It didn't repeal the offenses, but it repealed the cycle and the repeated fining people for the same conduct and helping people get back on the path, to the point of there are some very serious, some very benign. I think through work and through data and through analysis, there can be positive movement for communities or states to come together and say, okay, we don't want to use our resources this way anymore. So I have seen change and witnessed it for the better.
Well, Bernice, I think you bring up a really good point in that it's not a question. I'll get to more questions here, but I will say that in the state of Colorado, and I'm very proud of this with our governor, Governor Polis, he has formed a sentencing task force commission of folks all across the aisles, different prosecutors from around the state, defense lawyers, the public defender's office is represented. I have the privilege of having been appointed. I at first didn't want to. I rolled my eyes and thought, okay, here we go again. But I have to tell you that folks from the jail, sheriff's council, and everybody is in agreement. We started with misdemeanors, and it's sentencing reform and getting rid of old statutes on the book and restructuring all of it. 1,200 of them we started through. We were shocked at how many things were on the book that were not necessary, that were ridiculous, that people were getting arrested for, just like the professor talks about this petty offense policing, stuff that was just ridiculous to have contact with people. And we were all in agreement. There were very few disagreements about what not to get rid of and not to decriminalize. Now we're going to go into felonies. It may change a bit, but that states are actually taking the time to look at that as a community. I think that's where to start. I think it can make a difference. It cannot just be us, right? We cannot be the heavy lifters all of the time. Even if we have the professor writing all this great stuff for us, it has to be a lot of us. So, and the next question, Bernice, I'm going to ask you is, this individual says, what is the best way to divert individuals from the criminal justice? And we don't call it justice anymore. We call it the criminal legal system. What is the best type of pretrial diversion program that would allow criminal cases to be dismissed without a conviction? What should we do?
That's interesting. There are several types of diversions, but I think what you're talking about is a prosecutorial diversion, when the prosecutor has the ability to or the power or discretion to use. I think with respect to, I hate to keep using Indiana as the model, but that's where I work. So we have diversion here in Indiana, and it's, one bite at the apple. You get it one time and that's it. And it's really fully within the discretion of the prosecutor. So for us in Indiana, there's no uniform, I know that these 10 charges are eligible for a diversion. So I can go to with confidence to, this deputy prosecutor and seek diversion. So I think when I think of a good diversion system, it's one where there is not standardization, but where everyone can understand how it will be used. So when is it available? Transparency and when it's used would be really nice to know. I shared with you all that our Prosecuting Attorneys Council shares every year about charges that are brought. It's very difficult. Only recently have they started providing diversion information, which I think is very helpful to know how often are they using their discretion to divert people. But in Indiana, we also have at the end of a diversion, if the person is eligible, we do have a very nice expungement statute that can expunge the arrest from a person's record. So not only is it's not a conviction, it goes away, but the arrest can go away as well. So I would say advocate for a system if you don't have it, where there's uniform expectation around the diversion and an expungement if you don't have that in your system as well, to expunge the arrest as well.
If I can just take that one, I just want to take that one step further.
Yeah.
So the best diversion program is declination, no charge at all.
Yeah.
And it is part, I think it's fair to say that it is central part now of the platforms of so many progressive prosecutors now taking office all over the country. Their declination policies before anyone even gets to diversion, before there's a criminal charge. So I've worked with the DA's office in Los Angeles, George Gascon, Rachel Rollins in Suffolk County, in Boston. It was famous for running on a platform of declination. She promised to decline a list of 15 low-level misdemeanor offenses like the ones we've been talking about: loitering, trespassing, low-level drug possession. And I think that in advocacy, and I know we haven't talked about litigation yet, but this is sort of pre-litigation, Bernice, I guess, because it is up to the prosecutor, but there's a lot of fodder now. There's a lot of argument for pointing out that a declination, in other words, no charge at all, that the arrest is already punitive. That the person has already been incarcerated because of the arrest, that they've already suffered these consequences, that there's a conversation around the difference between policing and prosecution that I think is really rich. And it's a place for arguing for charges to be declined so that people are never put into the system at all. And to be a little base about it, it saves the system a lot of resources. It's prosecutor time, it's jail time, it's public defense time, it's court time, it's programmatic time. Do we really want to be spending that money on pro forma diversion programs where everyone expects the case to be dismissed at the end of the day anyway? I think it's a moment that we are rethinking that question.
Thank you for bringing
I think
that.
it's important, but I will say this: when you're a defender, you pick up cases where they've already been filed. So the frustration for defenders, and this is the disparity in the system. Once again, when you're poor, you don't have this advantage. As a private lawyer, that's the focus of what I do. My folks know when they're under the eye of law enforcement. They come to me, and a lot of my work is to make sure charges are never filed or declinations. When I was a public defender, I already got you when the case is filed. And to go backwards doesn't happen, except unless it's a diversion or deferred judgment. So I think, Professor Natapov, what you're talking about is exactly that economic disparity. Those folks who don't have the means get screwed in the system once again, even with a great policy of declination that may be out there. It's super frustrating. I don't know, Bernice. That's my frustration about it.
Well, and I'm glad that you brought up declination. So the Indianapolis prosecutor, Ryan Mears, made an announcement that he was not going to prosecute any small level marijuana possession.
Make it legal.
Agreed. But we're in Indiana. But his rationale was because law enforcement was so disparate in their enforcement and policing that he was not going to be a tool in that. So for equity's sake, he made the announcement. Well, in response, our police force, IMPD, said, well, we're still going to arrest people. And then our legislative response is that there was a bill filed to, it was called non-compliant prosecutors. It was essentially to take authority away. So when a prosecutor did make a declination that I'm not going to pursue X types of charges, then our state attorney general could come into that county and prosecute instead. Now, thank goodness that didn't pass, but those are like the mindsets and the forces that we're working with here. So even when you have a just prosecutor who's working to do right, there are all these other forces as well.
This goes to the point we were talking about before about why race matters.
Mm-hmm.
You cannot understand that story about a prosecutor saying these are racially disparate prosecutions I do not want to engage in. And he's not alone. The Brooklyn DA did that. A number of prosecutors, Rachel Rollins did, all over the country are recognizing that one of the ways to reduce racial disparities in the criminal system is through these policies. We can't, as a defense bar, understand that story without understanding the role of racism and the role of racial disparities in shaping each step along the way. So it's just one more plug for us being educated and sensitive about how these questions are intersecting with what we do.
Absolutely, absolutely. Jason Williams in New Orleans is also one of those who's really doing some incredibly fantastic work. Professor Natapov, this is for you, and it's a kind of long question from Ms. Seuss. In his book, Discipline and Punish, Foucault describes the state apparatus as an institution of discipline. The far-reaching consequence of misdemeanor convictions extend past a criminal record, including rejection of public housing and the things that you talked about collaterally. Powerfully, you describe this as the process is the punishment. What is your recommendation for public defenders for advocacy outside of the confines of their jobs description, specifically changing court rules or other legislative actions?
Thank you. I just was able to pull it up. So you don't often get a question about Foucault in a series like this. So Foucault was a French philosopher who wrote about theories of social control, for everybody who hasn't read him recently. And he wrote a book famously called Discipline and Punish, in which he talked about not just the criminal system, but the whole state apparatus, and all kinds of social institutions and how they change the way we look at each other, how the state controls what's seen as good behavior, what's seen as bad behavior. And so it was sort of locating what we typically think of as criminal punishment in this larger analytic picture. And so the question, what can we do outside of our role as litigators, as advocates for individuals, it's a wonderful question. I think that the defense bar has been having this conversation for a long time. I think, Lisa, you mentioned holistic representation models and community representation models as one sort of label for how we can see the defense function embedded in larger issues in the communities that we work in. I'll just share a pet peeve of mine, which is, as an academic, I've always thought that it was just a crushing loss that everyone in the defense bar is sworn to confidential secrecy, because the repository of insight and knowledge and information about how the criminal system really works, we have sworn to secrecy, essentially the professional class that could best speak and analyze and share and push back against some of the stereotypes and the racism and the assumptions that people tell about our clients. So I've always thought it was a terrible loss that the defense bar didn't have more public spaces to share these insights and these understandings. And I always say this when I talk to defense organizations, when I've talked to the NACDL and others, if you want to become a professor, let me know. There are many now former defense attorneys and former public defenders in the legal academy, writing and teaching and talking about these issues in a way that, you know, really wasn't as true 15 years ago. But working in the community, educating ourselves about the significance of all of these racial and economic issues, and then being aware of the large scale changes that are occurring in and around the criminal system. I know we're going to get to litigation soon, but there's so many exciting, groundbreaking things that are happening. And even just making sure that our offices, I say our offices as if I was still a public defender, which I realize is not fair, but in these communities so that we understand, you know, the alliances that can be made and the partnerships that can be built.
Lisa, may I?
Sorry, yes, please.
So this is part of what I do for a living is I, you know, advocate for legislative change. So part of my answer to this person would be observe the landscape of advocacy. And I'm not just saying legislative, rule change as well. That was an excellent point. And see the bodies that are making those changes. You must have where you are, I would assume, some sort of public defense, criminal justice advocacy body. Get plugged in. I'm constantly asking public defenders to engage. And the benefit of that has been they've been able to find clients. We've had former clients come and testify on this is what happened to me. And it is the most compelling. Every time that we've been able to do that, lawmakers afterwards say, thank you. Thank you for bringing people. We love having you attorneys come, but people who've walked this walk are the most meaningful to us. That's what was told to me. So, and in addition to the work you do, I mean, we definitely have had public defenders who have shared their stories with us. And we've been able to compile situations where we can say, this is how this statute is being abused. We can show you in 10 different counties, you know, that this is happening, X, Y, Z. So bring your voice. It's needed, it's wanted. So I would just say, get familiar with the advocacy landscape and get plugged in.
Absolutely. And I think I remember as a defender, you know, I thought my community was enough. We were a family, and you know how we are, we're like righteous about our cause and nobody else can be involved in it. And we were tired too. I mean, you got your cases and then you try to have family life and outside. So it can be tiring, but you know, I'm going to give a little bit of a plug to NACDL at this point, because having an organization that you can also be part of that does front the policy and the things that that all of us care about, that's what we do. And belonging, joining committees, whatever you need to do, reaching out to me, Bonnie Hoffman, Monica Reed, we make sure that your voice is heard in a bigger community that can sometimes do things. So I think Bernice knows that, and your state is just as important. So I agree with all that. And, you know, we've talked about having a panel discussion on being an activist and being a defender. Can you reconcile the two, or are they in conflict with each other? It's a super interesting discussion, one that was not taking place when I became a defender, frankly. So we're going to do that. We're going to keep going here, but I think that is really important. So we want to get to the litigation because I think there's some questions here talking about what can we do, what's the difference that we can make. And I know Professor Natapov and Bernice, the litigation issue is important. I'll start with this one, the driving under suspension. Driving under suspension is normally done because someone has prior episodes of driving where they've lost their license, traffic offenses are built up, they've gotten too many points, they haven't paid their tickets. It's a number of events that lead to a suspension. When I was a young public defender, it was one of the litigation arenas that helped me go, when I did go to felonies, of attacking prior convictions. So going back to the record of the prior convictions that got the person suspended in the first place, and doing collateral attacks or direct attacks on those prior convictions. It was awesome litigation as a young lawyer. Oftentimes those prior convictions were invalid or illegal, or Rule 11 wasn't done, or there wasn't a transcript, or the client did not have a lawyer where they should have been appointed a lawyer. So there was a lot of fertile ground in that area, and that's litigation and a space that Bernice is talking about that is very important. So Professor, I know you have a lot of other ones, but I love the litigation aspect.
I'll just talk for a second about the individual litigation, and then I want to talk about some of the systemic litigation that's going on around the country. So, you know, as we've been talking about all afternoon, because this is such an underappreciated arena, actually, there are a lot of issues that have just not been dealt with. You know, they haven't been litigated because people didn't have lawyers with resources. They didn't have the attention. And those issues, I tell my students, do not assume that, that issues have been litigated. If you spot something, it may be that nobody cared. As Bernie said, nobody gave a damn until now. The only, I was only a public defender for 4 or 5 years. The only case of any note that I ever litigated was a misdemeanor, because no one had litigated whether under Daubert, the field sobriety tests were sound scientific evidence. Just turned out no one had bothered. And so as a baby defender, I got to take on that issue. Some of the litigation around the country, and I'm sure folks know about it, the debtor's prison, the fines and fees, sort of post-Ferguson, challenge to the money that is driving so many of the dynamics of the misdemeanor system. That's all relatively new litigation. The civil rights advocates, started this less than 10 years ago, who went into courts and observed these bail practices and these fines and fee impositions, and said that former public defender Alec Karakatsanis, who's the head of Civil Rights Corps, he was fresh out of I think it was PDS. He was a public defender, PDS, and a federal public defender. He goes to court and sees that it's unconstitutional, and no one's doing anything about it. He goes home, he files a motion. And it has been nothing but fertile since then. And I asked him, if you take a look at the book, you'll see I interviewed him and asked him, how come so blatantly unconstitutional, no Bearden hearings, no determination of ability to pay. How come no one did it before you? He said, nobody, we just got used to it. Everybody thought it was just normal. So I think that the misdemeanor space is one of those under-litigated spaces where you can see things that other people have not seen. It's not that it's already there, it's that you know things that other people don't know. Fines and fees, bail, driving on a suspended license, the violation of the right to counsel. These are big systemic issues that are being litigated in almost every state now, and there are resources. There are nonprofit organizations that you don't have to reinvent the wheel. They're doing this work, so there's so many opportunities.
And I think the NACDL misdemeanor report also talks a lot about that kind of litigation as well. Bernice, what are you seeing some of your lawyers doing? I'm sure there are lawyers out here in the audience that have some really great litigation ideas too. So send it to us, so I'll talk about you. But what are you seeing, Bernice, in terms of the litigation?
It's as the professor said, Indiana has just real fertile ground for sure. We're having some challenges beginning around some access to witnesses issues that are unique to Indiana. There was recently a statute passed that where the complaining witness is a child in a sex charge, that the defense essentially created a presumption that they could not depose the child, which Indiana has a very liberal deposition rule. We can depose anybody generally, but so we've seen some good litigation around that, and a lot of bail issues, but there's a lot more. Our agency is working to sort of develop what we're going to call a hit list of issues that we'd like to see challenged, and offer support to people who raise those issues. So we'll have more good stories to share, I'm sure, soon.
Good. And we're trying to, we have a brief bank and emotions bank, and we try to stay on top of that for everyone, because we get reinventing the wheel, particularly when you have so many cases, can be so difficult, but preserving these issues. So motions to dismiss because of the pandemic, the speedy trial issue is something that's going to be rearing its head, because so many folks were, incarcerated, or their speedy trial, and I think those issues are going to be really ripe. And the makeup of your jurors. We just had in the Southern District of New York 2 days ago, a federal defender won the challenge to the grand jury makeup of the racial makeup of the grand jury. So that's pre-indictment stuff, but challenging those, who's coming into the courtroom. If I got 6 jurors on a misdemeanor, who are those jurors? Is the racial makeup of those jurors, are they going to be fair? Does it matter in this case? Making those kind of challenges are significant, and that's the intersection of race at the time we're at right now. We have to pay attention, even if you're in white jurisdictions, and that's probably even more important. But in Colorado, where I practiced for so many years, it was the rare case to see people of color on my panels. It just wasn't happening, and it was just, that's how it was. You tried the cases, you realized how to voir dire on the issue of race. So I probably got that down because of the lack of jurors, but those challenges are something that needs to be done, and I think we're going to see a lot of that. So staying in connection with each other, right, so that we know that, and reading the professor's next book about litigation. I don't know if she's teeing that up, but so that we have those kind of allies, it makes it
Bernice is going to write that, right?
In her free time, right, Bernice? So one of the other questions is, let's see, thank you so much for the presentation. I struggle to get prosecutors and judges to recognize these systemic issues that affect the individual cases I have. Do you have suggestions on how we can make the approach, right, do this? And what are those?
I wonder, as I hear that question, and I understand the challenge. I wonder if there's a partnership in their association, maybe a judicial association or a prosecutorial association, to see what their leadership is saying about issues. Maybe if they have a web page, et cetera, see what their concerns are, what they're raising, if anything. So kind of some reconnaissance there to see what they're concerned about in their area, and then see if you can get one of their own ilk to bring them along on systemic issues. Is what I have found helpful, is if they could hear it out of the mouth of another judge or another prosecutor, that might be helpful.
Professor Natapov, what do you suggest? I mean, how do you make the approach to these folks that's going to convince? We give them your book, we get that. So we're going to get a bunch of copies of your book, and then we're going to hand that over to them. But how do you, change these folks' minds?
I think it's chicken and egg, really, that the whole national conversation is changing. Mm-hmm. So it's not just, us sending an email, it's recognizing that these issues are changing. The Suffolk County DA's office just screened the film that many of you have now watched, Racially Charged, for the whole office, so that they could start to have a meaningful internal conversation about how they as an office want to handle it. I think that there's more, maybe think is too strong, I hope that there's more appreciation for how the community sees these issues these days. Mm-hmm. If we've learned nothing from the last year, from the year of George Floyd, it's that it matters how communities understand the criminal system. And sometimes it can be indirect. It can be a community conversation to which you invite a prosecutor or to which you invite a judge. I'll just note that the film Brave New Films is a nonprofit, so the screening is free. Anybody who wants to screen the film for any organization, any school, any group can do it for free. You can get a free copy of the book with the screening. There's not supposed to be a financial barrier to doing this, but it's a way of starting a conversation in a community that may be other stakeholders can be invited to.
And we totally agree with that. And I sent it out in my community saying, I think that not only should all lawyers watch it, but I sent it to Professor Ann England, who I think is on at the University of Colorado. I said, your students, because they run the clinics. A lot of these law schools are running the clinics that are dealing with misdemeanors. And, you know, they should see this. This is why it matters to them. And so we totally agree with that. And we hope that everybody does that. So we have a few minutes left here, and there were a couple more questions, and I know I didn't get to everybody, but there is an interesting question here about what should the takeaway be for prosecutors? What do you guys think about that? I didn't know there were prosecutors invited to this, so I was a little thrown off by the question, but I'm glad you're here and listening. And you know, I don't know personally, the takeaway is that you're listening to what's actually we're talking about here and what really matters to us and to our clients, and taking that back to your own offices and talking about it, and watch the screening of the movie. Prosecutors should watch this, right? Just like misdemeanor county court judges should watch this, to me. And I think you all spreading the word, I think defender offices, give this to your judges, talk about this with them, have roundtable discussions with everybody. There are no secrets here. That's how I feel about it. I don't know if Bernice and the professor agree with that, but that's how I feel.
Absolutely. Ask your office what your misdemeanor declination rate is.
Oh yeah.
I'll bet you $10 your office doesn't know. And ask what the racial breakdown of the declination rates are, because what we've seen in the few jurisdictions that have looked is that declination rates, like arrest rates and like sentencing and like prosecution, tend to be racially disparate. So lenience is accorded sometimes more often to white defendants than defendants of color. Even just knowing what your own office is doing can be a powerful basis for the conversation.
I would just like to add, thank you for being here. Thank you for being concerned about this topic. The prosecutor, of course, is the most powerful person in this whole equation. So I hope that your takeaway is that you're learning, that you're educating, and it ripples throughout your office, but I hope it ripples throughout. You take it to other prosecutors in your state, and you use what you learn to make your whole state system better, is what I hope your takeaway is.
And so Bernice, because I think you're so, so you're doing all this good work, and she's in the defender office. I feel a little, I feel it's very difficult for me to disagree with you, but I actually don't believe prosecutors are the most powerful people in the equation. I believe it's us. And the reason I believe that is what I think the last thing in this closing is, we need to try more misdemeanor cases. If we went to trial more frequently, we could back up the system and make a huge difference. But what's happened, and I think Professor Nadapov's book points us out, it's become mass plea court. That's what misdemeanor court has become, mass pleas. And we have the power to change that and stop that. And once we do, I mean, prosecutors got to do something, right? I mean, so we do hold that power. And I know what you meant, Bernice, I know, but I just don't want to message that we don't have the power, because I think we really do. And I think what Professor Nadapov has messaged to all of us in a really incredibly inspiring way is that we can do it as a community.